Warm welcome to all of you to the International Environment House here in Geneva, which is, of course, UNEP's home here in Geneva. So we're really delighted that you could make time to join us today when the International Court of Justice will be delivering its advisory opinion on the obligations of states in respect to climate change. The UN General Assembly has asked the court a little bit over 2 years ago to consider states' legal obligations to protect the environment from the adverse effects of climate change and the legal consequences under international law for failing to do so. It's worth underlining that the origin for this resolution can be found in the actions of law students from the Pacific Islands, aiming to protect their rights and those of future generations, who ultimately found the ears of delegations in New York, and this ultimately led to this important resolution and request to the International Court of Justice in The Hague, the outcomes of which we are hearing further on today, as I have said. The interest in the proceedings at The Hague was very, very high. With over 90 written statements in the initial phase, the ICJ received the highest number ever in terms of advisory proceedings. This was followed by 62 written comments, 2 weeks of public hearings at the end of last year, with 96 states and 11 international organizations appearing for oral statements. The breadth of the questions put to the ICJ is likely to provide greater clarity on states' obligations under multiple areas of international law relating to climate change, including potential liability for breach of those obligations. In their submissions, states and the international organizations have focused largely on 5 broad areas. They focused on states' obligations under the climate change treaties. They focused on the customary prohibition of significant transboundary harm and the precautionary principle. They honed in on the law of the sea, human rights, and the application of state responsibility. Today's opinion succeeds recent opinions by the International Tribunal for the Law of the Sea and the Inter-American Court of Human Rights, which provided greater clarity with regards to states' obligations relating to climate change in the context of the law of the sea and human rights, respectively. However, their conclusions do not provide a holistic assessment of states' climate obligations. Such an assessment is now expected from the opinion that will be rendered today. The potential relevance of today's opinion is enormous, even if the advisory opinion, of course, is not binding. And this relevance of today's opinion can also be felt, especially here in Geneva, which is the main international hub for human rights. But Geneva is also an important hub for multilateral action in the field of the environment, including climate action. Numerous debates and negotiations in the field of science, health, human rights, development, trade, green finance, employment, peace building and security, disaster risk reduction, humanitarian issues, as well as new technologies and innovation. It's a very long list indeed, but they all bear relevance in the context of today's opinion and vice versa. Today's screening is part of a series of events co-organized by the Geneva Environment Network, together with the Center of International Environmental Law and other stakeholders. And we had a similar sort of event last year in December at the Palais des Nations, when the public hearings in The Hague began. And this screening last year in December was also part of the Geneva Environment Network's 25th anniversary celebrations. And we have followed this on with a special event to unpack some key arguments that have been made before the court in The Hague. And since these events were successful, we, of course, could not do without having another event today when we conclude this process and when we finally have the opportunity to listen to the opinion rendered by the court. So today is the first time that the world's highest court has been asked to clarify states' obligations to protect our environment from climate change and the legal consequences of failing to meet these obligations. And it has the potential, as I have said, to reshape the landscape of international climate action in several ways going forward. And today we will have an opportunity to discuss these ways with our fantastic speakers that have joined us today. And so with these few words, I want to wish us all a very productive event. And I hand it over to Francesca Mingone from the Center of International Environmental Law. Francesca.
Thank you very much, and huge thanks to the Geneva Environment Network for hosting us today. Indeed, watching the live stream in the very home UNEP is definitely a very important symbol. The reason why we wanted to organize this watch party is also to reflect the sense of community that we've built in Geneva. We're here, state representatives, UN representatives, and non-governmental organizations, all working towards a similar goal, which is protecting human rights, the climate system. And I think that the level of engagement by states, as you were mentioning, international organizations, that was really unprecedented before the court, is also the result of so much build-up and collective work that has been done, including in Geneva. You already touched upon the origin of this process. Indeed, it's been 2 years in the making. Back in March, thanks to the initiative and the leadership of Vanuatu and the youth movement internationally, specifically the Pacific youth, we were really able to mobilize the international community and get the resolution that requested this advisory opinion passed by consensus. The advisory opinion that will be presented at 3 p.m., and we're very happy to be sharing this moment together, happens in the backdrop of 3 other important processes. The advisory opinion that was requested to the International Tribunal of the Law of the Sea back in December 2022 by the Commission of Small Island States on Climate Change and International Law. And the advisory opinion was delivered in May 2024 and states that in order to protect the oceans, states must take all available measures to cut greenhouse gas emissions which pollute the marine environment. Another important advisory opinion is the one that was just delivered earlier this month by the Inter-American Court on Human Rights. The focus is clearly on human rights obligations of states in the context of the climate emergency. And this is a very progressive and ambitious advisory opinion. Touches upon important dimensions like future generations, corporate accountability, defenders, the right to a healthy environment, remedy, rights of nature, procedural rights, and so on. So it's also our hope that the advisory opinion of the International Court of Justice will build on this advisory opinion by the regional system. But it was also interesting to see the potential of a new advisory opinion in the African context. Just in May 2025, a request was put forward before the African Court on Human Rights and People's Rights to look once again at states' obligations with regard to climate change. So if we look at this growing body of law and these advisory opinions, which have authoritative status and weight, we see that once they're all out, they will have to really be interpreted and used in a coherent manner. And they can, as you were saying, Arnold, really provide clarity on what states' obligations are. And indeed, the request to the International Court of Justice builds on 2 main pillars. On one hand, clarifying what states' obligations are under international law to ensure the protection of the climate system, but also what the legal consequences for states are in case they fail to meet these obligations. And particular emphasis is given to states that are particularly vulnerable to climate change, specifically small island developing states, and also peoples and individuals, including future generations that are affected by the climate crisis. During the hearings and also the written comments, we also heard a varied number of positions, of arguments. If you think that the court will have to look at all the bodies of international law, it's quite a daunting task. And also, it was challenging for states to develop clear and coherent arguments. We're talking about, as Arnold mentioned already, public international law, environmental law, human rights law, trade law, the law of the sea, customary law, and so on. But we have identified a few areas that I wanted to share with you also to give you a bit of a framework to better follow the explanation by the courts. And these are areas in which we've seen important divergence of views by states. Especially, we've heard more progressive stances by global south states, those states most vulnerable to climate change. They really want an ambitious and strong advisory opinion that make important points about accountability, remedy, also the centrality of human rights law. And others, mostly global north states, that actually want to restrain the scope of the applicable law, the consequences of failure to meet the obligations, and so on. And if we look at some of these areas, one of these is exactly the law governing states' obligations in relation to climate change. The question is, what law applies? Are we talking about just the Paris Agreement and the United Nations Framework Conventions on climate change, or should other sources of law apply? And that's a hope, of course, that the court will definitely have an interpretation that is very broad in terms of the scope of the applicable law. And also, how does the best available science inform the interpretation of legal obligations? Another important dimension that we expect to see addressed in the advisory opinion is the question of human rights of present and future generations. We've heard by many courts at the regional and national level, including, for instance, the European Court on Human Rights and the International Court on Human Rights, that climate change is a human rights issue. And so we also know that states have human rights obligations vis-a-vis both present and future generations. And so it's going to be interesting to see how the ICJ addresses the question of human rights body of law in the context of states' obligations, and also how this applies vis-a-vis future generations, which are explicitly mentioned in the request to the court. Another relevant dimension is the question of preventive and precautionary approach and what these entail in informing states' action on climate change. We all know that under international law, states have a long-standing duty not to cause or allow conduct that cause foreseeable harm to the environment in other states. And so states are required to take concrete action to prevent such harm from occurring. They have to regulate and control activities that occur or originate from their territory. And the recent climate advisory opinions by the ITLOS and the Inter-American courts have strongly affirmed the importance of these principles in all climate responses. So we really hope that also the International Court of Justice will shed light on these elements. Right of remedy and reparations and historical responsibility. If harms occur, what the obligations of states are to remedy to it. There is the question of loss and damage, but also the question of historical responsibility by those states that have caused most of the climate crisis so far. Equity and a just transition are also going to be a very important pillar, hopefully, in the advisory opinion. In the context of the climate change regime, the principles of equity and common but differentiated responsibilities are central and also mean that countries have a whole shared responsibility to address climate change, but their obligations vary based on their capacity and also how much they have contributed to the crisis. This is a very difficult sticking point, and so we will see how the court will position itself vis-a-vis this. Corporate accountability is also central, what states' obligations are with regard to regulating the private actors. And it will be interesting to see if anything is said also on fossil fuels phase out, not just with regard to the role of fossil fuels in driving the climate crisis, but also states' obligations with regard to regulating specifically the fossil fuel industry. In the Inter-American Court's advisory opinion, specific attention is given exactly to the fossil fuel industry, for instance. It's also interesting to see that at the end of the oral hearings, the court came up with 4 follow-up questions, to which states could then respond in writing. And I think that these questions really highlight some points and elements that were clear in the judge's mind and that we can expect then that it will be addressed in the opinion. Judge Cleveland made a specific question about obligations of states with regard to fossil fuel production. Judge Tladi noted the obligation under the Paris Agreement to mitigate and prepare nationally determined contribution. And the question is obligation a substantial or just a procedural one? Judge Aurescu asked a question about the content of the right to a healthy environment, which is emerging as a human rights at the international level. And finally, Judge Charles Worth asked about the relationship between the UNFCCC, the Paris Agreement, and other principles of general international law, including with regard to compensation and liability. So we'll see if the written replies to these specific questions also helped clarify and the court's position and hopefully get to an ambitious outcome. But irrespective of the final outcome, really the attention that is being given to climate change is unprecedented. The fact that the International Court of Justice has been asked to clarify these questions is also a historical turning point per se. With all of these in mind, we just wanted to seed in your mind some of these points. As I was saying, the leadership of Vanuatu, Pacific states, and the Pacific Youth was key. And this is why, before we start with the live stream, which will start in a few minutes, we wanted to show a short video message from Samira Ben Ali and Nicole Ponce from the World Youth for Climate Justice. They couldn't be here with us because they're all gathering in The Hague, of course, where the real action is happening. Maybe over to the video, and then we can make some housekeeping announcements. Thank you, Harvey.
Hi, my name is Samira Ben Ali. I'm the global campaign lead for the World Youth for
Hi
Climate
everyone, and I'm Nicole Ponce, the global advocacy lead for World Youth for Climate Justice. And we just want to really thank everyone for organizing the watch parties. We are with you in this long-awaited moment. The ICJ is going to give out its decision on the advisory opinion on climate change and human rights, and we are very excited and very hopeful.
Yeah, thank you so much for doing this event. I think that this event has been a long time coming. We know that it has been 6 years since a lot of people, many of you I'm sure in the room, have been working with us to make sure that from the Vanuatu classroom where this idea was born and to go into the world, and when all the youth in the world also assembled to that, you were also being part of this process, being extremely supportive, going towards states and asking them to make this proceeding happen because it could have the power to change and turn the tides for more climate ambitions.
Yeah, and I hope you feel the gravity of this moment because it means that the global majority of us, communities and peoples, got the world to listen. And now we have the world's highest court giving out its opinion on what we dare say one of the most important problems of our time to address. And here at World Youth for Climate Justice, we have always been very committed in empowering youth and building capacity and making sure we facilitate meaningful participation and experiences with our youth. I've personally seen our youth members engaging successfully with their governments, in fact, to the point of contributing to actual state submissions and making sure that principles such as intergenerational equity and speaking of present and future generations and of course the nexus between human rights and the climate crisis are included in their country's submissions, because this affects not only the present but the future generations, and hopefully we'll see that in the decision today.
Yes, we have a lot of expectation on that decision, and it's also not a decision that is going to be alone.
Thank you, everyone.
Thank you. Bye-bye.
Some youth energy. Thank you to Samira and Nicole. I think the beginning of the delivery is starting. I think one of the last points that they mentioned is how to build from the advisory opinion, and that's gonna be the focus of our second part. Once the live stream is over, we will hear from some experts some reactions. Of course, we don't know what the content will be, so we will try to improvise, share some hot reactions, and then also we want to open for Q&A, comments, reactions you might have. We hope to wrap up by around 4:30 or 5 p.m., depending on how long the delivery lasts. There's some coffee and biscuits outside, so also during the live stream, please feel free to stand up, hydrate yourself, get some biscuits, and then at the end of the event, we will also have some further refreshments to continue the conversation in a more informal manner. Thank you so much once again, and I think we can start the live streaming, hoping that the court will also start on time. Thank you.
Please be seated. The sitting is open. The court meets today pursuant to Article 67 of the statute to deliver its advisory opinion on the request submitted by the General Assembly of the United Nations on the question of the obligations of states in respect of climate change. I note the presence of His Excellency Philemon Young, President of the 79th session of the United Nations General Assembly in the Great Hall of Justice today, in addition to the representatives of the many states and international organizations that have taken part in these proceedings. The questions on which the advisory opinion of the court has been requested are set forth in Resolution 77/276, adopted by the United Nations General Assembly on 29 March 2023. By a letter dated 12 April 2023, the Secretary General of the United Nations officially communicated to the court the decision taken by the General Assembly to request the court to render an advisory opinion. The final paragraph of the resolution reads as follows. I quote, an advisory opinion on the following questions. Having particular regard to the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, the United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment. A, what are the obligations of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases for states and for present and future generations? B, what are the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to, 1, states, including in particular small island developing states, which due to their geographical circumstances and the level of development are injured or specifically affected by or particularly vulnerable to the adverse effects of climate change. 2, peoples and individuals of the present and future generations affected by the adverse effects of climate change. End of quote. In accordance with the usual practice, I shall not read out the introductory paragraphs of the opinion. These paragraphs set out the main elements of the procedural history of the proceedings. I shall also omit or summarize some of the other paragraphs of the opinion. I shall therefore begin the reading of the advisory opinion at paragraph 37. The full text of the opinion will of course be available at the close of the sitting. When seized of a request for an advisory opinion, the court must first consider whether it has jurisdiction to give the opinion requested, and if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request. The first question put to the court concerns the obligation of states under international law to ensure the protection of the climate system and other parts of the environment from anthropogenic emissions of greenhouse gases, which I shall refer to as GHGs, for states and for present and future generations. The second question concerns the legal consequences under these obligations for states where they, by their acts and omissions, have caused significant harm to the climate system and other parts of the environment with respect to states and peoples and individuals of the present and future generations affected by the adverse effects of the climate change. The court considers that these questions are legal questions. The court concludes that it has jurisdiction to render the requested opinion. It then concludes that there is no compelling reason for it to decline to give the opinion requested by the General Assembly. Turning to the relevant scientific background the court notes that the consequences of climate change are severe and far-reaching. They affect both natural ecosystems and human populations. These consequences underscore the urgent and existential threat posed by climate change. In its examination of the scientific aspects, the court relies primarily on the reports of the Intergovernmental Panel on Climate Change, which I shall refer to as the IPCC. Participants agree that these reports constitute the best available science on the causes, nature, and consequences of climate change. The court further observes that the adverse effects of climate change on the climate system have been acknowledged by the United Nations, including UNEP, and its special agencies such as the WMO, WHO, and the IMO. The IPCC defined the climate system as the global system consisting of 5 major components: the atmosphere, the hydrosphere, the cryosphere, the lithosphere, and the biosphere, and the interactions between them. For the purposes of this advisory opinion, the court notes that this definition is substantially equivalent to that of Article 1, Paragraph 3 of the United Nations Framework Convention on Climate Change, which I shall refer to as the Framework Convention. Article 1, Paragraph 3 of the Convention defines the climate system as the totality of the atmosphere, hydrosphere, biosphere, and geosphere, and their interactions. The IPCC has concluded with very high confidence that risks, projected adverse impacts, and related loss and damage from climate change will escalate with every increment of global warming. It added that these risks, projected adverse impacts, and related loss and damage are higher for global warming of 1.5 degrees Celsius than at present, and even higher at 2 degrees Celsius. Indeed, in 2018, the IPCC concluded with high confidence that, I quote, warming of 1.5 degrees Celsius is not considered safe for most nations, communities, ecosystems, and sectors, and poses significant risks to natural and human systems, end of quote. The court then turns to the scope of the questions posed by the General Assembly. Regarding their material scope, the court considers that the 2 questions put to it are interrelated and require the court to identify the obligation of states in respect of activities that adversely affect the climate system, as well as the legal consequences arising from the breach of these obligations. In this regard, the court is further of the view that the relevant conduct for the purposes of these advisory proceedings is not limited to conduct that in itself directly result in GHG emissions, but rather comprises all actions or omissions of states which result in the climate system and other parts of the environment being adversely affected by anthropogenic GHG emissions. The court considers that the material scope of its inquiry encompasses the full range of human activities that contribute to climate change as a result of the emission of GHGs, including both consumption and production activities. Turning to the territorial scope of the request, it follows from the court's conclusions on the material scope of the questions put to it that the General Assembly did not intend to impose any territorial limits to the court's inquiry. The court is requested to formulate its reply not in respect of any particular territory or regions, but in global terms, especially since GHG emissions are unequivocally caused by human activities which are not territorially limited. With regard to the temporal scope of the request, the court observes that while temporal issues may be particularly relevant for an in concreto assessment of the responsibility of states for breaches of obligations pertaining to the protection of the climate system, the present opinion is not concerned with the invocation and determination of the responsibility of individual states or group of states. Rather, the present opinion considers the legal obligation of all states under question A and identifies the relevant legal regime applicable to legal consequences arising under those legal obligations in its reply to question B. Concerning the scope of question A, the court notes that the unqualified reference to obligations under international law indicates the intention of the General Assembly to seek the court's opinion on the obligations incumbent upon states under the entire corpus of international law, and not to limit the court's reply to any particular source or area of international law. With regard to the scope of question B, the court observes that this question is connected with question A insofar as it refers to the obligations enumerated in question A. Thus, the legal consequences to be determined by the court are those arising from the various obligations under international law, which the court is called upon to identify under question A. In the court's view, nothing in question B indicates that the General Assembly intended to request the court to opine on the legal consequences, if any, for injuries arising out of acts not prohibited by international law. The court considers that it has been requested to address legal consequences in a general manner, and that it is not called upon to identify the legal responsibility of any particular state or group of states. It also bears noting in this context that the responsibility of individual states or group of states requires an in concreto assessment that must be undertaken on a case-by-case basis. In its view, in relation to question B, the court is only called upon first to establish the applicable legal framework of state responsibility in respect of states that have breached their obligations to protect the climate system, and second, to outline in general terms the legal consequences flowing therefrom. In doing so, the court does not prejudge the merits of any future claims that may be brought in relation to the subject matter of the present proceedings before courts or tribunals. As for legal consequences, with respect to a certain category of states that are especially affected or are particularly vulnerable, the court notes that the application of rules of state responsibility under customary international law does not differ depending on the category or status of an injured state. Thus, specifically affected states or states that are particularly vulnerable are in principle entitled to the same remedies as other injured states. The challenges faced by certain states, owing to their geographical circumstances and level of development, are governed by the relevant primary rules of international law, and thus will be addressed by the court in relation to the relevant obligations of states under question A. The court observes that the second part of question B inquires about the legal consequences with respect to peoples and individuals of the present and future generations affected by the adverse effects of climate change. The court considers that whether individuals have any entitlement to invoke the legal responsibility of states or to make a claim in a particular circumstance involving injury or harm arising from climate change is dependent on the relevant primary obligations of states. Having defined the scope and meaning of the questions posed by the General Assembly, the court then addresses question A and begins by considering the applicable law. In its request, General Assembly invites the court to have particular regard to, I quote, the Charter of the United Nations, the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social, and Cultural Rights, the United Nations Framework Convention on Climate Change, the Paris Agreement, United Nations Convention on the Law of the Sea, the duty of due diligence, the rights recognized in the Universal Declaration of Human Rights, the principle of prevention of significant harm to the environment, and the duty to protect and preserve the marine environment, end of quote. The phrase, particular regard to, while indicating that the wide range of international legal rules and principles are potentially relevant, does not mean that the General Assembly requests the court to address every rule of international law, including the obligations contained therein in respect of climate change. The court therefore identifies the most directly relevant applicable law governing the questions of which it has been seized. It first identifies those rules which are most directly relevant and thereafter determines whether any of those rules are excluded by virtue of the interpretative principle of lex specialis. The court begins with the Charter of the United Nations, which is a pillar of contemporary international law. The Charter provides that the member states shall act in accordance with certain principles, such as the fulfillment in good faith of the obligations assumed by states under the Charter, including when addressing problems of common concern, such as climate change. Accordingly, Charter forms part of the most directly relevant applicable law. The court then turns to the applicability of the climate change treaties. It observes that the Framework Convention, the Kyoto Protocol, and the Paris Agreement are the principal legal instruments regulating the international response to the global problem of climate change. These instruments complement each other. Framework Convention establishes the ultimate objective as well as the basic principles and general obligation of states in respect of climate change. Whereas the Kyoto Protocol and Paris Agreement respectively translate these basic principles and general obligations into a set of more specific interrelated obligations, each of which gives expression to a broad, practical approach of the community of states parties to the problem of climate change. The court thus concludes that the three climate change treaties, namely the Framework Convention, the Kyoto Protocol, and the Paris Agreement, form part of the most directly relevant applicable law. In view of the court, UNCLOS also forms part of the most strictly relevant applicable law. With respect to other environmental treaties, the court considers that the following treaties form part of the most directly relevant applicable law, given their close connection with the issue of climate change. The Vienna Convention for the Protection of the Ozone Layer, which I shall refer to as the Ozone Layer Convention, the Montreal Protocol on Substances that Deplete the Ozone Layer, which I shall refer to as the Montreal Protocol, the Convention on Biological Diversity, which I shall refer to as the Biodiversity Convention, and the United Nations Convention to combat desertification in those countries experiencing serious drought and/or desertification, particularly in Africa, which I shall refer to as the Desertification Convention. The court is aware that there are many other treaties which are relevant for the efforts of the international community of states to address the global problem of climate change. However, it confines itself to examining the most directly relevant applicable law regarding climate change. The court then goes on to consider the applicability of the relevance of customary international law. In the advisory opinion on the legality of the threat or use of nuclear weapons, the court affirmed that the duty to prevent significant harm to the environment is not confined to instances of direct cross-border harm, and that it applies to global environmental concerns. In the court's view, the customary duty to prevent significant harm to the environment also applies with respect to the climate system and other parts of the environment. The duty to prevent significant harm to the environment is an obligation to act with due diligence. The conduct required by due diligence has several elements to which I shall return later. Determination of what is required by due diligence ultimately calls for an assessment in concreto of what is reasonable and under the specific circumstances in which a state finds itself. However, this does not exclude the identification of a required standard of conduct at the general level, depending on the overall character of the risk to the parts of the environment in question. This is particularly apposite with respect to climate change, because the specific character of the risk of significant harm to the climate system is indisputably established. Climate change poses a quintessentially universal risk to all states. This risk is of a general and urgent character, requiring the identification of a corresponding general standard of conduct to be applied subject to the principle of common but differentiated responsibility and respective capabilities. Under these circumstances, the court recognizes that the standard of due diligence for preventing significant harm to the climate system is stringent. As concerns climate change, a heightened degree of vigilance and prevention is required. The court concludes that the duty of states to prevent significant environmental harm applies in the context of climate change, and that this duty forms part of the most directly relevant applicable law. Concerning the duty to cooperate, the court recalls that it lies at the core of the Charter of the United Nations and has been spelled out in the Foundational Declaration on Friendly Relations. Court has held that the adoption by states of this text affords an indication of their opinio juris as to customary international law. That observation also applies to the duty to cooperate, insofar as it finds expression in many binding, non-binding instruments relating specifically to the environment. The duty to cooperate is a central obligation under the climate change treaties and other environmental treaties. In view of the related practice of states, the court considers that the duty of states to cooperate for the protection of the environment is a rule whose customary character has been established. This duty to cooperate is intrinsically linked to the duty to prevent significant harm to the environment, because uncoordinated individual efforts by states may not lead to a meaningful result. It also derives from the principle that the conservation and management of shared resources and the environment are based on shared interests and governed by the principle of good faith. For these reasons, the court considers that the duty to cooperate for the protection of the environment forms part of the customary international law and can also serve as a guiding principle for the interpretation of other rules. It forms part of the most directly relevant applicable law. Turning to human rights law, the court considers that the core human rights treaties and the human rights recognized under customary international law form part of the most directly relevant applicable law. The court then examines whether certain principles are part of the applicable law for the purposes of the present advisory opinion. It concludes that the principles of sustainable development, common but differentiated responsibilities and respective capabilities, equity, intergenerational equity, and the precautionary approach or principle are applicable as guiding principles for the interpretation and application of the most strictly relevant legal rules. The court finally turns to the question of whether any of the rules identified above are excluded by virtue of the interpretative principle of lex specialis. This question concerns the relationship between the climate change treaties and other rules of international law. The court notes at the outset that it is a generally recognized principle that when several rules bear on the single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. The principle of lex specialis is a maxim of interpretation that is used for determining which of several potentially applicable rules is to prevail, or whether the rules simply coexist. The application of the lex specialis principle depends on the circumstances of each case. The court cannot find any actual inconsistency between the provisions of the climate treaties and other rules and principles of international law that may be relevant for the response to question A. On the contrary, the preambles to the Framework Convention and the Paris Agreement themselves contain references to other rules and principles. The state parties to these treaties have thereby recognized that climate change constitutes a problem for whose solution other rules and principles also play a role. Nor can the court identify a discernible intention of the parties to the climate change treaties generally to displace other possibly applicable rules or principles. There is in particular no indication that the climate change treaties are meant to apply while simultaneously excluding general custom international law or other treaty rules on the protection of the environment. For these reasons, the court considers that the argument according to which the climate change treaties constitute the only relevant applicable law cannot be upheld and finds that the principle of lex specialis does not lead to a general exclusion by the climate change treaties of other rules of international law. The court emphasizes that it has determined only the applicable law which is most strictly relevant for answering question A put to it by the General Assembly. This determination is without prejudice to other rules of international law that may also be relevant under various circumstances in the context of climate change. The court then of states under the Climate Change Treaty framework, which comprises 3 legal binding instruments concluded by states to address the problem of climate change caused by anthropogenic GHG emissions, namely the Framework Convention, the Kyoto Protocol, and the Paris Agreement. The court takes into consideration the rules, principles, mechanisms, and institutions established under the climate change treaties in order to identify and clarify the obligation of the parties. In this context, the key principles that permeate all 3 climate change treaties are those contained in Article 3 of the Framework Convention. These guiding principles include common but differentiated responsibilities and respective capabilities, the precautionary approach of principle, sustainable development, equity, and intergenerational equity. The court recalls that while these principles do not constitute standalone obligations within the climate change treaty framework, they guide the interpretation of the treaty obligations. In interpreting their obligations under the climate change treaties, states also need to have recourse to the relevant decisions of the governing bodies of these treaties, which are the Conference of the Parties of the Framework Convention, the Conference of the Parties serving as the meeting of the parties to the Kyoto Protocol, and the Conference of the Parties serving as the meeting of the parties to the Paris Agreement. The court observes that in certain circumstances, the decision of these bodies have certain legal effects. First, when the treaty so provides, the decision of Conference of Parties may create legally binding obligations for the parties. Second, decisions of these bodies may constitute subsequent agreements under Article 31, paragraph 3A of the Vienna Convention on the Law of Treaties, insofar as such decisions express agreement in substance between the parties regarding the interpretation of the relevant treaty. The Court observes that it is not required to address each and every obligation of the parties under the climate change treaties. It focuses its inquiry on the main obligations of states under the Framework Convention, the Kyoto Protocol, and the Paris Agreement pertaining to the obligation to protect the climate system from anthropogenic GHG emissions, which it considers may be grouped broadly into obligations of mitigation, adaptation, and cooperation. Concerning the relationship between the Framework Convention, the Kyoto Protocol, and the Paris Agreement, the Court observes, with respect to the applicability of lex posterior rule, that it is only where the treaties are incompatible, i.e., the obligations cannot be complied with simultaneously, that the later in time obligations will supersede the earlier obligation. The mere fact that the treaties regulate the same subject matter does not necessarily constitute a conflict or result in one superseding the other. In the view of the Court, there is no incompatibility between the three climate contraries. They are mutually supportive, with the Kyoto Protocol and Paris Agreement providing greater specification to the general obligations contained in the Framework Convention. The Court turns to the obligation of parties under the Framework Convention. It observes that the Framework Convention provides a general framework for addressing the problem of climate change caused by anthropogenic GHG emissions. In this connection, the Framework Convention addresses the full range of GHGs, with the exception of those already controlled by the Montreal Protocol. The ultimate objective of the Framework Convention, as set out in Article 2, is to achieve stabilization of GHG concentrations in the atmosphere at the level that would prevent dangerous anthropogenic interference with the climate system, and to ensure that such a level should be achieved within a time frame sufficient to allow ecosystems to adapt naturally to climate change, to ensure that food production is not threatened, and to enable economic development to proceed in a sustainable manner. A key feature of the Framework Convention is the distinction it draws between developed country parties and developing country parties, which are subject to differing obligations. The Framework Convention accomplishes this by providing for specific additional obligations on certain developed country parties and other parties listed in Annex 1, which I shall refer to as Annex 1 parties. The main obligations under the Framework Convention concerning mitigation are to be found in Article 4, Paragraph 1. The Court observes that certain obligations under this provision, such as those to develop, update, publish, and make available national inventories of anthropogenic GHG emissions and removals by sinks, the obligation to formulate and publish national programs, and the obligation to communicate information to the COP are obligation of result. Other obligations under Article 4, Paragraph 1 are obligations of conduct because they do not require parties to bring about a particular result, but rather require parties to use their best efforts to achieve certain results relating to mitigation. In the court's view, the obligations under Article 4, Paragraph 1 are interconnected obligations of conduct and result. The court further observes that Article 4, Paragraph 2 sets forth a number of distinct but interrelated mitigation obligations that are legally binding for Annex 1 parties. The court finds it necessary to recall that all obligations identified are legally binding upon the parties to which they pertain, regardless of whether the obligation in question is one of result or one of conduct. As the court has observed, the distinction between obligation of conduct and obligation of result is not necessarily a strict one. It must be stressed that both types of obligations may result in the responsibility of a state for breach of the relevant obligation. With regard to adaptation obligations under the Framework Convention, the court observes that adapting to the adverse effects of climate change is, along with mitigation, a major area of action for parties under the Framework Convention. Several provisions of the Framework Convention refer to obligations relating to adaptation. These provisions, like all provisions in Article 4, Paragraph 1, are introduced with the term shall and are legally binding in nature. While the aforementioned obligations pertain to all parties, Article 4, Paragraph 4 of the Framework Convention provides that Annex 2 parties shall assist the developing country parties that are particularly vulnerable to the adverse effects of climate change in meeting the cost of adaptation to those diverse effects. This is a legally binding obligation on all parties that are listed in Annex 2. The court further observes that the Framework Convention establishes an obligation for parties to cooperate in different areas, including in mitigation and adaptation. The court considers that international cooperation is indispensable in the field of climate change, and that the customary duty to cooperate for the protection of the environment is reflected in several provisions of the climate change treaties. The duty to cooperate is an obligation of conduct, the fulfillment of which is assessed against a standard of due diligence. The court then turns to the Kyoto Protocol, to the Framework Convention. The court notes that the absence of a new commitment period after 2020 does not deprive the Kyoto Protocol of its legal effect. Kyoto Protocol remains in force, and the provisions may still serve as, inter alia, 1, interpretative aids for the identification of the obligations under the Climate Change Treaty framework, and 2, substantive provisions to assess the compliance of Annex B parties with applicable emission reduction targets, i.e., to determine whether a state during the relevant commitment period has complied with its emission reduction commitments. Thus, non-compliance with emission reduction commitments by a state may constitute an internationally wrongful act. The court then addresses the obligation of state parties to the Paris Agreement. As a general matter, the court notes that while the Paris Agreement provides for limiting the global average temperature increase to well below 2 degrees Celsius above pre-industrial levels as a goal, and to 1.5 degrees Celsius as an additional effort, 1.5 degrees Celsius has become the scientifically based consensus target under the Paris Agreement. In this connection, the Court refers to decisions of the meeting of the parties to the Paris Agreement. In the Court's view, these decisions express the agreement in substance between the parties regarding the interpretation of Articles 2 and 4 of the Paris Agreement, and thus constitute subsequent agreements in relation to the interpretation of the Paris Agreement within the meaning of Article 31, Paragraph 3A of the Vienna Convention on the Law of Treaties. Accordingly, the Court considers the 1.5 degrees Celsius threshold to be the parties' agreed primary temperature goal for limiting the global average temperature increase under the Paris Agreement. The Court notes that the principle of common but differentiated responsibilities and respective capabilities has been formulated differently in the Paris Agreement through the addition of the phrase, I quote, "in the light of different national circumstances," end of quote. In the view of the Court, the additional phrase does not change the core of the principle of common but differentiated responsibility and respective capabilities. Rather, it adds nuance to the principle by recognizing that the status of a state, the developed or developing, is not static. It depends on an assessment of the current circumstances of the state concerned. The Court also notes that the Paris Agreement contains several obligations of conduct and obligations of result, which are mutually supportive. With regard to obligation of conduct, parties are required to act with due diligence. Thus, the compliance of parties with their obligation of conduct under the Paris Agreement is assessed on the basis of whether the party in question exercised due diligence and employed best efforts by using all the means at its disposal in the performance of that obligation. The Court turns to mitigation obligations under the Paris Agreement. It recalls that mitigation involves human intervention to reduce emissions or enhance carbon sinks. The Court notes that the mitigation obligation of state parties under the Paris Agreement are set out in Article 4. The Court observes that the achievement of the temperature goal set out in Article 2 of the Paris Agreement constitute, in addition to the object and purpose of the agreement, the context relevant for the interpretation of other obligations found elsewhere in the Paris Agreement, such as the mitigation obligation under Article 4. The Paris Agreement reinforces the obligations relating to the promotion and enhancement of carbon sinks and reservoirs set forth in Article 4 of the Framework Convention. To achieve its objectives, Paris Agreement establishes obligations concerning nationally determined contributions, which I shall refer to as NDCs, whereby parties outline and communicate their climate actions. Under Article 4, Paragraph 2, each party must first prepare, communicate, and maintain the successive NDCs that intends to achieve And second, parties must pursue domestic mitigation measures with the aim of achieving the objectives of such contributions. This provision set forth two binding legal obligations, which must be performed by parties individually. In respect of the obligation to prepare, communicate, and maintain successive NDCs, the Court observes that this obligation is procedural in nature and constitutes an obligation of result. Therefore, the failure to prepare, communicate, and maintain successive NDCs, to account for them, and to register them would constitute a breach of the obligations set out in Article 4 of the Paris Agreement. The mere formal preparation, communication, and maintenance of successive NDCs is not sufficient to comply with the obligations under Article 4. The Court then turns to the question of whether and the extent to which the content of the NDCs is left to the discretion of each party under the scheme of the Paris Agreement. The Court considers that this question depends on the interpretation of Article 4. First, the clause in Article 4, paragraph 3, which states that each party's successive NDCs will represent a progression beyond that party's current NDCs, means that the party's NDCs must become more demanding over time. Second, a party's NDCs must reflect its highest possible ambition. While this term is not defined in the Paris Agreement, the Court considers that the level of ambition to be reflected in a party's NDCs has not been left entirely to the discretion of the parties. The provision reveals that the content of a party's NDCs must be capable of making an adequate contribution to the achievement of the temperature goal. In light of the above, the Court considers that the discretion of parties in the preparation of their NDCs is limited. As such, in the exercise of their discretion, parties are obliged to exercise due diligence and to ensure that their NDCs fulfill their obligations under the Paris Agreement. In the current context, because of the seriousness of the threat posed by climate change, the standard of due diligence to be applied in preparing NDCs is stringent. This means that each party has to do its utmost to ensure that the NDCs it puts forward represent its highest possible ambition in order to realize the objectives of the agreement. The obligation to prepare and communicate NDCs applies to all parties. However, consistent with the varying character of due diligence and the practice of common but differentiated responsibilities and respective capabilities, the standard to be applied when assessing the NDCs of different parties will vary, depending inter alia on historical contributions to cumulative GHG emissions and the level of development and national circumstances of the party in question. In light of the foregoing, the Court concludes that rather than being entirely discretionary, as some participants argued, NDCs must satisfy certain standards under the Paris Agreement. All NDCs prepared, communicated, and maintained by parties under the Paris Agreement must, when taken together, be capable of realizing the objectives of the agreement, which are set out in Article 2. The court turns next to the obligation contained in the second sentence of Article 4, Paragraph 2, which concerns the implementation of NDCs and domestic mitigation measures. The court underlines that the obligation for parties to pursue domestic mitigation measures is substantive in nature and creates individual obligations for each party to the agreement. Moreover, this obligation is one of conduct and not of result. Accordingly, the parties are required to act with due diligence in taking necessary measures to achieve the objectives set out in their successive NDCs. In the present instance, the court considers that the standard of due diligence attaching to the obligation to pursue domestic mitigation measures is stringent on account of the fact that the best available science indicates that the risks and projected adverse impacts and related loss and damage from climate change escalate with every increment of global warming. Turning to adaptation obligations under the Paris Agreement, the court finds that specific obligations pertaining to adaptation are contained in Article 7, Paragraph 9 of the Paris Agreement. This provision imposes legally binding obligations upon the parties to undertake adaptation planning actions. The court considers that the fulfillment of parties' adaptation obligations is to be assessed against the standard of due diligence. It is therefore incumbent upon parties to enact appropriate measures that are capable of enhancing adaptive capacity, strengthening resilience, and reducing vulnerability to climate change. In this connection, parties must use their best possible efforts in line with the best available science. Finally, the court observes that the adaptation obligations under the Paris Agreement complement the mitigation obligations in preventing and reducing the harmful consequences of climate change. Next, the court notes that the Paris Agreement establishes obligations of cooperation with respect to specific issue areas such as adaptation and loss and damage. As observed earlier, in respect of the obligation to cooperate under the Framework Convention, such obligations exist for states both under conventional international law, including Articles 7, 9, 12 of the Paris Agreement, and customary international law. These coexisting obligations inform each other, and in the present instance, the court considers that the customary duty to cooperate for the protection of the environment reinforces the treaty-based cooperation obligations under the Paris Agreement. The court notes that states are free to select the means of cooperating as long as such measures are consistent with the obligation of good faith and due diligence. The court considers that the principal forms of cooperation prescribed by the Paris Agreement are financial assistance, technology transfers, and capacity building. For all these reasons, the court considers that the climate change treaties establish stringent obligations upon states to ensure the protection of the climate system and other parts of the environment from anthropogenic GHG emissions. The court then turns to the obligation of states under customary international law relating to climate change. With regard to the duty to prevent significant harm to the environment, the Court considers that it also applies to the climate system, which is an integral and vitally important part of the environment and which must be protected for present and future generations. There are two main elements of this duty: the environmental harm to be prevented and due diligence as the required standard of conduct. For the duty to prevent to arise, there must be a risk of significant harm to the environment. This is the case either where no harm has yet been caused, but the risk of future significant harm exists, or where some harm has already been caused and there exists a risk of further significant harm. Whether an activity constitutes a risk of significant harm depends on both the probability or foreseeability of the occurrence of harm and its severity or magnitude. It should therefore be determined by, among other factors, an assessment of the risk and level of harm combined. The degree of a given risk of harm is always an important element for the application of the due diligence standard. The higher the probability and the seriousness of possible harm, the more demanding the required standard of conduct. The Court is of the view that the risk of significant harm may also be present in situations where significant harm to the environment is caused by the cumulative effect of different acts undertaken by various states and by private actors subject to their respective jurisdiction on control, even if it is difficult in such situations to identify a specific share of responsibility of any particular state. State must assess the possible cumulative effects of their acts and the planned activities under their jurisdiction or control. In the context of climate change, it is the sum of all activities that contribute to anthropogenic GHG emissions over time, not any specific emitting activity, which produces the risk of significant harm to the climate system. The risk associated with the climate change is a consequence of a combination of activities by different states, and that states need to avert the risk through a coordinated and cooperative response. The determination of significant harm to the climate system and other parts of the environment must take into account the best available science. The question whether any specific harm or risk of harm to a state constitute a relevant adverse effect of climate change must be assessed in concreto in each individual situation or case. Accordingly, the Court considers that the diffuse and multifaceted nature of various forms of conduct which contribute to anthropogenic climate change does not preclude the application of the duty to prevent significant harm to the climate system and other parts of the environment. With regard to due diligence as a required standard of conduct, the Court reaffirms that states must fulfill their duty to prevent significant harm to the environment by acting with due diligence. The following elements are particularly relevant when it comes to determining what due diligence requires from a state in a particular situation, including in the context of climate change. First, appropriate rules and measures, including but not limited to regulatory mitigation mechanisms that are designed to achieve the deep, rapid, and sustained reductions of GHG emissions that are necessary for the prevention of significant harm to the climate system, and adaptation measures. Second, the availability of and the need to acquire and analyze scientific and technological information. Third, current standards that may arise from binding and non-binding norms, and that may be reflected in certain decisions of the Conference of Parties, the climate change treaties, and in recommended technical norms and practices. Fourth, the capabilities of a state as reflected in the principle of common but differentiated responsibilities and respective capabilities. Fifth, scientific information regarding the probability and seriousness of possible harm, as states should not refrain from or delay taking actions of prevention in the face of scientific uncertainty. Six, the duty to exercise due diligence in preventing significant harm to the environment also required states to take certain procedural steps, including conduct of a risk assessment and environmental impact assessment and notification and consultation, which are particularly warranted when an activity significantly affects collective efforts to address harm to the climate system. Turning to the duty to cooperate for the protection of the environment, the court recalls that it has customary character. The court emphasizes the importance of cooperation in the context of a resource shared by a limited number of states. This applies even more to the climate system, which is a resource shared by all states. Cooperation between states is the very foundation of meaningful international efforts with respect to climate change. The duty to cooperate requires sustained and continuous forms of cooperation, of which treaties and their coordinated forms of implementation are a principal expression. While states are not required to conclude treaties, they are required to make good faith efforts to arrive at appropriate forms of collective actions. States must cooperate to achieve concrete emission reduction targets or a methodology for determining contributions of individual states, including with respect to the fulfillment of any collective temperature goal. The court recognizes that the duty to cooperate leaves states some discretion in determining the means for regulating their GHG emissions. However, this discretion cannot serve as an excuse for states to refrain from cooperating with the required level of due diligence, but to present their effort as an entirely voluntary contribution, which cannot be subjected to scrutiny. The court then turns to the relationship between obligations arising from treaties and those arising from customary international law relating to climate change. The court recalls that the treaty rules and rules of customary international law as norms belonging to two sources of international law retain a separate existence. However, when several norms bear on a single issue, they should, to the extent possible, be interpreted so as to give rise to a single set of compatible obligations. The climate change treaties establish standards that may enable or facilitate the identification and application of the diligence that is due in specific instances. The Court also considers that the obligations arising from the climate change treaties, as interpreted herein, and state practice in implement them, inform the general customary obligations, just as the general customary obligations provide guidance for the interpretation of the climate change treaties. As it is difficult to determine in the abstract the extent to which the climate change treaties and their implementation practice influence the proper understanding of the relevant customary obligations and their application, the Court considers that at the present stage, compliance in full and in good faith by a state with the climate change treaties, as interpreted by the Court, suggests that this state substantially complies with the general customary duties to prevent significant environmental harm and to cooperate. This does not mean, however, that the customary obligations will be fulfilled simply by states complying with their obligations under the climate change treaties. While the treaties and customary international law inform each other, they establish independent obligations that do not necessarily overlap. It follows from the above that the customary obligation of any state, which is not the party to one or more of the climate change treaties at present, find expression, at least in part, in the general practice of states, which is in accordance with the obligations under the climate change treaties, as interpreted herein. Customary obligations are the same for all states and exist independently regardless of whether a state is a party to the climate change treaties. On this basis, the Court considers that it is possible that a non-party state which cooperate with the community of state parties to the 3 climate change treaties in a way that is equivalent to that of a state party may, in certain circumstances, be considered to fulfill its customary obligations through a practice that comports with the required conduct of states under the climate change treaties. However, if a non-party state does not cooperate in such a way, it has a full burden of demonstrating that its policies and practices are in conformity with its customary obligations. The Court then addresses the obligation of states under other environmental treaties. It examines in turn the relevant obligations in the Ozone Layer Convention, the Montreal Protocol, the Biodiversity Convention, and the Desertification Convention, and concludes that the obligations under those treaties are obligations that contribute to ensuring the protection of the climate system as a whole. The Court considers that the environmental treaties it addresses, the climate change treaties, and the relevant obligation under customary international law inform each other. State parties must therefore take their obligations under these environmental treaties into account when implementing the obligations under the climate change treaties and under customary international law, just as they must take their obligations under the climate change treaties and under custom international law into account when implementing their obligations under these environmental treaties. The court then turns to the obligation of states under UNCLOS. The court is of the view that anthropogenic GHG emissions may be characterized as pollution of the marine environment within the meaning of UNCLOS. The court therefore considers that Part 12 of UNCLOS on the protection of the marine environment is applicable in the context of anthropogenic GHG emissions and is thus relevant to answering question A in the present advisory proceedings. On this basis, the court considers the most relevant obligation of states under UNCLOS to ensure the protection of the climate system. In the view of the court, the obligation under Article 192 of UNCLOS consists of a positive obligation to take measures to protect and preserve the marine environment and a negative obligation not to degrade it. Standard of due diligence to be applied when complying with the obligation to protect and preserve the marine environment is stringent. The court also observes that state parties are, under Article 194, Paragraph 1 of UNCLOS, under an obligation to take all necessary measures to reduce and control pollution with the ultimate aim of preventing its occurrence altogether, although they are not required to ensure an immediate cessation of marine pollution caused by anthropogenic GHG emissions. In the view of the court, it is not necessarily sufficient for state parties to fulfill their obligations under the Framework Convention and the Paris Agreement in order to satisfy the obligation laid down by Article 194, Paragraph 1 of UNCLOS. The court considers that what constitutes a necessary measure within the meaning of that provision should be assessed according to objective criteria, taking into account the best available science, international rules and standards relating to climate change, and the available means and capabilities of the state concerned, including their different national circumstances. With regard to the obligation to cooperate under Article 197 of UNCLOS, the court is of the view that it is an obligation of conduct which requires states to act with due diligence. This obligation is of a continuing nature, and it requires state parties inter alia to make ongoing efforts to formulate and elaborate rules, standards, and recommended practices and procedures. The adoption of treaties for the protection of climate system, such as the Framework Convention or the Paris Agreement, does not release state parties from this requirement under UNCLOS. The court further considers that UNCLOS, the climate change treaties, and other relevant environment treaties, as well as the relevant obligations under custom international law, inform each other. The court then turns to the obligation of states in relation to sea level rise and related issues. With respect to sea level rise and its implications, the court considers that the provisions of UNCLOS do not require state parties in the context of physical changes resulting from climate change-related sea level rise to update their charts or list of geographical coordinates that show the baselines and outer limit lines of their maritime zones once they have been duly established in conformity with the Convention. For this reason, state parties to UNCLOS are under no obligation to update such charts or list of geographical coordinates. The court notes that several participants argued that sea level rise also poses a significant threat to the territorial integrity and thus to the very statehood of small island states. In their view, in the event of the complete loss of a state's territory and the displacement of its population, a strong presumption in favor of continued statehood should apply. In the view of the court, once a state is established, the disappearance of one of its constituent elements would not necessarily entail the loss of its statehood. The court then turns to the obligation of states under international human rights law. At the outset, it notes that the environment is the foundation for human life, upon which the health and well-being of both present and future generations depend. The court thus considers that the protection of the environment is a precondition for the enjoyment of human rights. The court notes that the adverse effects of climate change, including inter alia, the impact on the health and livelihoods of individuals through events such as sea level rise, drought, desertification, and natural disasters may significantly impair the enjoyment of certain human rights, including the right to life. The court considers that conditions resulting from climate change, which are likely to endanger the lives of individuals, may lead them to seek safety in another country or prevent them from returning to their own. In the view of the court, states have obligations under the principle of non-refoulement, where there are substantial grounds for believing that there is a real risk of irreparable harm to the right to life if individuals are returned to their country of origin. The court is also of the view that the adverse effects of climate change may significantly impair the effective enjoyment of such human rights as the right to health, the right to an adequate standard of living, which for its part encompasses access to food, water, and housing, the right to privacy, and the rights of women, children, and indigenous peoples. The court considers that a clean, healthy, and sustainable environment is a precondition for the enjoyment of many human rights, such as the right to life, right to health, and the right to an adequate standard of living, including access to water, food, and housing. The right to a clean, healthy, and sustainable environment results from the interdependence between human rights and the protection of the environment. Consequently, insofar as state parties to human rights treaties are required to guarantee the effective enjoyment of such rights, it is difficult to see how these obligations can be fulfilled without at the same time ensuring the protection of the right to a clean, healthy, and sustainable environment as a human right. The human right to a clean, healthy, and sustainable environment is therefore inherent in the enjoyment of other human rights. the court thus concludes that under international law, the human right to a clean, healthy, and sustainable environment is essential for the enjoyment of other human rights. With regard to the territorial scope of certain universal human rights treaties that are relevant to answering question A, the court recalls that it has previously recognized the applicability of human rights treaties when a state exercises jurisdiction outside its territory. In the context of the present advisory proceedings, the court need not determine the specific circumstances under which a state can be regarded as exercising its jurisdiction outside its own territory, since any such determination depends on the provisions of each treaty. The court emphasizes in this regard that the scope of human rights treaty law and that of customary law are distinct. Taking into account the adverse effect of climate change on the enjoyment of human rights, the court considers that the full enjoyment of human rights cannot be ensured without the protection of the climate system and other parts of the environment. In order to guarantee the effective enjoyment of human rights, states must take measures to protect the climate system and other parts of the environment. Under international human rights law, states are required to take necessary measures in this regard. The court is of the view that international human rights law, the climate change treaties, and other relevant environmental treaties, as well as the relevant obligations under customary international law, inform each other. States must therefore take their obligations under international human rights law into account when implementing the obligations under climate change treaties and other relevant environmental treaties and under customary international law. Just as they must take their obligations under the climate change treaties and other relevant environmental treaties and under customary international law into account when implementing their human rights obligations. The court then turns to question B. As observed earlier, the court considers that this question concerns the legal consequences arising for states that have breached any of the obligations identified in relation to question A. In respect of question B, the court's task is to identify in a general manner the legal framework under which the conduct of states can be assessed in order to determine whether a state or group of states is responsible for a breach of its obligations pertaining to the protection of the climate system and the remedies that are available to the injured state or states in case of such a breach. The court observes that the participants in these proceedings are divided in their views as to whether the general rules on state responsibility apply in the context of climate change, or whether the legal consequences are solely or primarily governed by the climate change treaty framework. With regard to the question of applicability of the rules on state responsibility under question B, the court notes that those rules do not vary with the nature of the wrongful act in question in the absence of a clearly expressed lex specialis. In order for the lex specialis maxim to apply, there must be some actual inconsistency or else a discernible intention that one provision is to exclude the other. The court finds that the text, context, and object and purpose of the climate change treaties do not support the proposition that the parties intended to exclude the general rule on state responsibility. In particular, the court finds no evidence in Articles 8 and 15 or in the procedural mechanisms thereunder of any discernible intention on the part of the parties to Paris Agreement to derogate from the customary international law rules on state responsibility for breaches of those treaty obligations. The court concludes that responsibility for breaches of obligations under the climate change treaties and in relation to the loss and damage associated with the adverse effects of climate change is to be determined by applying the well-established rules on state responsibility under customary international law. The unprecedented nature and scale of harm resulting from climate change give rise to particular issues in relation to the application of the customary rules on state responsibility. Chief among these issues are questions relating to attribution and causation, which the court addresses in turn. In considering the alleged difficulties in attributing actions or omissions to a state, the court emphasizes at the outset that attribution is to be based on criteria determined by international law. In the court view, the well-established rule of international law that the conduct of any organ of a state must be regarded as an act of that state is applicable in the context of climate change. Failure of a state to take appropriate action to protect the climate system from GHG emissions, including through fossil fuel production, fossil fuel consumption, the granting of fossil fuel exploration licenses, or the provision of fossil fuel subsidies, may constitute an internationally wrongful act, which is attributable to that state. The court also emphasizes that the internationally wrongful act in question is not the emission of GHGs per se, but the breach of conventional and customary obligations identified under question A, pertaining to the protection of the climate system from significant harm resulting from anthropogenic emissions of such gases. In relation to private actors, the court observes that the obligations it has identified under question A include the obligation of states to regulate the activities of private actors as a matter of due diligence. Therefore, attribution in this context involves attaching to a state its own actions or omissions that constitute a failure to exercise regulatory due diligence. Thus, a state may be responsible where, for example, it has failed to exercise due diligence by not taking the necessary regulatory and legislative measures to limit the quantity of emissions caused by private actors under its jurisdiction. The court further notes that some participants submitted that it is difficult to invoke responsibility in the context of climate change, given that the wrongful conduct is cumulative in nature, involving different states over a period of time and involving a plurality of states that cause injury to a plurality of injured states. In this respect, the court observes that while climate change is caused by cumulative GHG emissions, it is scientifically possible to determine each state's total contribution to global emissions, taking into account both historical and current emissions. What constitutes a wrongful act is not the emissions in and of themselves, but actions or omissions causing significant harm to the climate system in breach of a state's international obligations. Furthermore, with respect to the invocation of responsibility for conduct involving a plurality of states that causes injury to a plurality of states, the court acknowledges that the fact that multiple states have contributed to climate change may indeed increase the difficulty of determining whether and to what extent an individual state's breach of an obligation identified in question A has caused significant harm to the climate system. However, the court considers that in principle, the rules on state responsibility and the custom international law are capable of addressing a situation in which there exists a plurality of injured or responsible states. Therefore, in the climate change context, the court considers that each injured state may separately invoke the responsibility of every state which has committed an internationally wrongful act resulting in damage to the climate system and other parts of the environment. And where several states are responsible for the same internationally wrongful act, the responsibility of each state may be invoked in relation to that act. With regard to causation, the court begins by observing that causation of damage is not the requirement for the determination of responsibility as such. Causation or causality is a legal concept that plays a role in determining reparation. Since reparation implies the existence of damage, causation must be established between the wrongful act of a state or group of states and particular damage suffered by the injured state, or in the case of a breach of obligation under international human rights law, by the injured individuals. In the court's view, the fact that the damage was the result of concurrent causes is not sufficient to exempt a state from any obligation to make reparation. The existing legal standard for establishing causation, which has been developed in the jurisprudence of the court, is capable of being applied to the establishment of causation between the internationally wrongful acts of non-compliance with states' obligations to protect the climate system and the damage suffered by states as a result of such a wrongful act. The court is of the view that the required legal standard of a sufficiently direct and certain causal nexus between alleged wrongful action or omission and the alleged damage is flexible enough to address the challenges arising in respect of the phenomenon of climate change. The court observes that causation involves two distinct elements. First, whether a given climate event or trend can be attributed to anthropogenic climate change, and second, to what extent damage caused by climate change can be attributed to a particular state or group of states. While the second element must be established in concreto in respect of specific claims brought by states in respect of damage, in many cases, the first elements may be addressed by recourse to science. The scientific evidence adduced in these proceedings establishes that significant harm to the climate system has been caused as a result of anthropogenic GHG emissions. The court has observed in the past, I quote, "In cases of alleged environmental damage, particular issues may arise with respect to the existence of damage and causation. The damage may be due to several concurrent causes or the state of science regarding the causal link between the wrongful act and the damage may be uncertain. These are difficulties that must be addressed as and when they arise in light of the facts of the case at hand and the evidence presented to the court." End of quote. In light of the foregoing, the court concludes that while the causal link between the wrongful actions or omissions of a state and the harm arising from climate change is more tenuous than in the case of local sources of pollution, this does not mean that the identification of a causal link is impossible in the climate change context. It merely means that the causal link must be established, in each case, through an in concreto assessment. The court then turns to the question whether the character of certain obligations identified under question A result in any special legal consequences for states. In the present context, the court considers that all states have a common interest in the protection of global environment commons, like the atmosphere and the high seas. Consequently, states' obligations pertaining to the protection of the climate system and other parts of the environment from anthropogenic GHG emissions, in particular the obligation to prevent significant transboundary harm under customary international law, are obligations erga omnes. In the treaty context, the court recalls that the Framework Convention and the Paris Agreement acknowledge that climate change is a common concern of humankind, requiring a global response. These treaties seek to protect the essential interests of all states in safeguarding the climate system, which benefits the international community as a whole. As such, the court considers that the obligation of states under these treaties are obligations erga omnes partes. As a result, all state parties have a legal interest in the protection of the main mitigation obligations set forth in the climate change treaties and may invoke the responsibility of other states for failing to fulfill them. The court then turns to the legal consequences arising from wrongful acts. The court cannot, in the context of these advisory proceedings, specify precisely what consequences are entailed by the commission of an internationally wrongful act of breaching obligations to protect the climate system from the anthropogenic GHG emissions, since such consequences, depending on the specific breach in question and on the nature of the particular harm. As a general observation, the court notes that breaches of state obligations under question A may give rise to the entire panoply of legal consequences provided for under the law of state responsibility. The court also notes that breaches of state's obligations do not affect the continued duty of the responsible state to perform the obligation breached. Under customary international law, a state responsible for an internationally wrongful act is under an obligation to cease that act if it is continuing, and if the breached obligation is still in force. In this context, the court is of the view that the obligation to put an end to the wrongful act may require a state to revoke all administrative, legislative, and other measures that constitute an international wrongful act of that state. The duty of cessation may also require states to employ all means at their disposal to reduce their GHG emissions and to take other measures in a manner and to the extent that ensures compliance with their obligations. Additionally, in appropriate circumstances, a responsible state could be required to offer appropriate assurances and the guarantees of non-repetition. Concerning the duty to make reparation, the appropriate nature and quantum of reparations cannot be assessed in the abstract and depends on the circumstances of a particular case. The court observes that the remedy of restitution, which involves the re-establishment of the situation that existed before the wrongful act was committed, may prove difficult or unfeasible in the case of environmental harm, since such harm is often not easily reversible. Nevertheless, the court considers that in the circumstances of climate change caused by emissions of GHGs, restitution may take the form of reconstructing damaged or destroyed infrastructure and restoring ecosystems and biodiversity. Whether or not these special forms of restitution are appropriate as reparation for damage suffered by states in relation to climate change is to be determined on a case-by-case basis. Such determinations cannot be made in the abstract. In the event that restitution should prove to be materially impossible, responsible states have an obligation to compensate. The court considers that it is within the scope of this opinion to consider whether compensation could be owed for significant harm caused by climate change, if a sufficiently direct and certain causal nexus can be shown between the wrongful acts of one or more states and the resulting harm. In the climate change context, reparation in the form of compensation may be difficult to calculate, as there is usually a degree of uncertainty with respect to the exact extent of the damage caused. Finally, whether satisfaction is warranted for a violation by a state or states of obligations regarding the emission of GHGs and what form that satisfaction could take will depend on the nature and circumstances of the breach. Before concluding, the court recalls that it has been suggested that these advisory proceedings are unlike any that have previously come before the court. At the same time, as the court concluded earlier, the questions put to it by the General Assembly are legal ones, and the court, as a court of law, can do no more than address the questions put to it through and within the limits of its judicial function. This is the court's assigned role in the international legal order. However, the questions posed by the General Assembly represent more than a legal problem. They concern an existential problem of planetary proportions that imperils all forms of life and the very health of our planet. International law, whose authority has been invoked by the General Assembly, has an important but ultimately limited role in resolving this problem. A complete solution to this daunting and self-inflicted problem requires the contribution of all fields of human knowledge, whether law, science, economics, or any other. Above all, a lasting and satisfactory solution requires human will and wisdom at the individual, social, and political levels to change our habits, comforts, and current way of life in order to secure a future for ourselves and those who are yet to come. Through this opinion, the court participates in the activities of the United Nations and the international community represented in that body with the hope that its conclusions will allow the law to inform and guide social and political action to address the ongoing climate crisis. For these reasons, the court, 1, unanimously finds that it has jurisdiction to give the advisory opinion requested. 2, unanimously decides to comply with the request for an advisory opinion. 3, as regards question A put by the General Assembly, A, unanimously is of the opinion that the climate change treaties set forth binding obligations for state parties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following. A, state parties to the United Nations Framework Convention on Climate Change have an obligation to adopt measures with a view to contributing to the mitigation of greenhouse gas emissions and adapting to climate change. B, state parties listed in Annex 1 to the United Nations Framework Convention on Climate Change have additional obligations to take the lead in combating climate change by limiting their greenhouse gas emissions and enhancing their greenhouse gas sinks and reservoirs. C, state parties to the United Nations Framework Convention on Climate Change have a duty to cooperate with each other in order to achieve the underlying objective of the convention. D, state parties to the Kyoto Protocol must comply with the applicable provisions of the protocol. E, state parties to the Paris Agreement have an obligation to act with due diligence in taking measures in accordance with their common but differentiated responsibilities and respective capabilities, capable of making an adequate contribution to achieving the temperature goal set out in the agreement. F, state parties to the Paris Agreement have an obligation to prepare, communicate, and maintain successive and progressive nationally determined contributions, which, inter alia, when taken together, are capable of achieving the temperature goal of limiting global warming to 1.5 degrees Celsius above pre-industrial levels. G, state parties to the Paris Agreement have an obligation to pursue measures which are capable of achieving the objectives set out in their successive nationally determined contributions. And H, state parties to the Paris Agreement have obligations of adaptation and cooperation, including through technology and financial transfers, which must be performed in good faith. B, unanimously, is of the opinion that customary international law sets forth obligation for states to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following. A, states have a duty to prevent significant harm to the environment by acting with due diligence and to use all means at their disposal to prevent activities carried out within their jurisdiction or control from causing significant harm to the climate system and other parts of the environment in accordance with their common but differentiated responsibilities and respective capabilities. B, states have a duty to cooperate with each other in good faith to prevent significant harm to the climate system and other parts of the environment, which requires sustained and continuous forms of cooperation by states when taking measures to prevent such harm. C, unanimously, is of the opinion that state parties to the Vienna Convention for the Protection of the Ozone Layer and to the Montreal Protocol on substances that deplete ozone layer and its Kigali Amendment, the Convention on Biological Diversity, and the United Nations Convention to combat desertification in those countries experiencing serious drought and or desertification, particularly in Africa, have obligations under these treaties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. D, unanimously, is of the opinion that state parties to the United Nations Convention on the Law of the Sea have an obligation to adopt measures to protect and preserve the marine environment, including from the adverse effects of climate change, and to cooperate in good faith. E, unanimously, is of the opinion that states have obligations under international human rights law to respect and ensure the effective enjoyment of human rights by taking necessary measures to protect the climate system and other parts of the environment. 4, as regards question B, put by the General Assembly, unanimously is of the opinion that the breach by a state of any obligations identified in response to question A constitute an internationally wrongful act entailing the responsibility of that state. The responsible state is under a continuing duty to perform the obligation breached. The legal consequences resulting from the commission of an internationally wrongful act may include the obligations of A, cessation of the wrongful actions or omissions if they are continuing, B, providing assurances and guarantees of non-repetition of wrongful actions or omissions if circumstances so require, and C, full reparation to injured states in the form of restitution, compensation, and satisfaction, provided that the general conditions of the law of state responsibility are met, including that a sufficiently direct and certain causal nexus can be shown between the wrongful act and injury. I shall now call upon the registrar to read the operative part of the opinion in French.
Par ces motifs,
For these reasons, the Court, 1, unanimously finds that it has jurisdiction to give the advisory opinion requested. 2, unanimously decides to comply with the request for an advisory opinion. 3, as regards question A, put by the General Assembly, A, unanimously is of the opinion that the climate change treaties set forth binding obligations for states parties to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions. These obligations include the following.
Maybe a round of applause. Thanks for bearing with us. I mean, it was the very last words. I think we definitely got the substance and the gist of it. Personally, it's been very emotional to witness that. We weren't in The Hague, but being here in Geneva and also having next to me people that I worked closely also to make some of these points around the importance and centrality of human rights, the right to healthy environment, the importance of reparation, what the consequences of breach of such obligations are, is really emotional. Conscious of time, I wanted to make sure we cannot really provide a full wrap up of what has been said. Some further analysis will come out. Some of the sticking points that I had mentioned at the very beginning were confirmed by the court, I would say in the best possible way. Very strong arguments about the importance of harmonious interpretation of different sources of law, which means that beyond UNFCCC and Paris Agreement, a wide range of treaties apply, but most importantly, principles of public international law, environmental law, and to us, most importantly, human rights law. Very important to hear that the court recognized that the human right to a clean, healthy, and sustainable environment is part of the corpus juris of international law. This is something that we keep pushing for in Geneva, and having the highest court reaffirm that it's incredibly important. And we hope that it will also inform processes at the international level, whether it's climate change, plastic, and so on. The question of future generations also was touched upon. The role of fossil fuels in driving the climate crisis. The court discussed a lot the question of due diligence and what a standard of due diligence is, stressing that it's a stringent one, given the urgency of and the impact of the climate crisis. And then, of course, the questions around what the consequences are. The court says that it's hard to assess in concrete and in detail what specific consequences are, but definitely builds on the existing norms of international law regarding reparation and cessation, no repetition of the harmful conduct, restoration, and compensation. I want to give the floor quickly to Yves from Earth Justice. You've been working very closely with many of us, many states, to really push a human rights-based climate action, and especially around the prominence of human rights and the right to healthy environment. So if you want to share some reactions based on what the court just said, and then I will turn over to Ben.
Okay, well, thank you very much. Sorry, as you said, Francesca, it is a bit emotional. Indeed, sorry, because we have been fighting for quite a long time here in the Geneva framework to say how much the environmental law instruments and how these issues were closely related to the question of human rights, and it's being a whole journey in order to have this being recognized. It has been generally over the last years clearly recognized, and the adoption by the Human Rights Council and afterwards by the UNGA of the resolution recognizing the right to a healthy and sustainable environment were already quite an achievement. But what we've been hearing today from the highest body, the International Court of Justice, about how all of these elements have to be articulated together sets a definitive point on this type of argument. We unfortunately still hear too much that these are separate things, they should never be discussed together, and they're separate elements. They're not. We've always been defending this, and now it has been very clearly stated by the International Court of Justice. So I think this is definitely a turning point in such discussion, and I really hope that this will help to go forward in the use of international law to face some of the huge challenge that we have. I mean, I really want to quote again the words that were said at the end about this daunting and self-inflicted process, because definitely this is something that we need to look at very, very seriously. Perhaps another element which strikes me also when we compare some of the trends we're facing today in politics, generally speaking, all over the world, and when we hear the court, I think it shows also why more and more people are going to courts on these issues, because we see that there is, unfortunately, absolutely everywhere, at different degrees, of course, but absolutely everywhere, a tendency now that we are entering in the hard stuff on climate change, because we saw that a few weeks ago with the heat waves. But we have so many events. Also, what happened, for example, in Texas. Let's never forget also what had happened in the Philippines, in Pakistan, and so on. So many events which are just confirming and now adding up more and more, that it's really what we see now, that we're getting to this very tough aspect of it. It's not an abstraction anymore. We see how political forces are trying basically to minimize the real obligations that have been set, to try even to minimize this reality, and to try to walk away from their responsibility and their obligation. And I think here we have a clear reminder, because the process that came from the International Court of Justice that we just heard is that they look at the severity of the damage, how it is clearly scientifically documented, what are the obligations on this that had been established by the different parties, by all of the parties, when they decided to take up the issue, and then, of course, what are the legal consequences. And when we hear a number of the speeches at the political level, we see how now there is this trend to walk away from these realities, the physical realities and the legal realities. And I think what the ICJ is saying here is this has now to stop and has to be taken seriously. You see what the damage are happening right now, how they are going to increase. That is what was announced, and that is what is going on right now. So when we stop this tendency to try to relabel what's happening under other type of terminology, and then you have, as states, there are obligations, and these obligations also apply in the way you set up the rules for the private actors. So I think here we have really a very comprehensive and very solid reasoning in order to see how we should act in the coming years. So I think definitely this was a turning point for a number of aspects in this discussion, and probably I'll give the floor here to Ben on the different consequences in the field of human rights. But definitely this has been a very important moment, and I must say that at a personal level, to hear pronounced by the judge some of the sentences we've been repeating again and again in the framework of the Human Rights Council or in other bodies here in Geneva was quite an important moment. I was not expecting the decision of the International Court of Justice to be so clear. Actually, I was fearing that there would be a lot of nuances and so on. No, it's clear, straightforward. And as I said, I think it's a very important moment.
Ben, you want to share some points also, given your role in the Office of the High Commissioner for Human Rights, and a lot of the work that has been done by your office also with regard to loss and damage and everything around reparations?
Yes, thank you very much. And I gotta say, I had no idea how anxious I was about this decision until sitting here with you all, and I feel really a huge sense of relief and validation for all of the work that we've done, much of it mandated by the Human Rights Council over the last 10 years on human rights and climate change. Because as Yves just said, what we just heard from the court is affirming, the human rights obligations of states. It's affirming the right to a clean, healthy, and sustainable environment. And they didn't have to necessarily go there, but they did, and they did it very clearly. And affirming the obligation to use the highest ambition possible, stating 1.5 as the new goal of the Paris Agreement. That interpretation, drawing upon the best available science, drawing upon subsequent decisions of the Paris of the Conference of the Parties to the UNFCCC. I mean, I think those things are really important. Another thing that they did, and we're very clear about, was saying that compliance with the climate agreements may not be enough to fulfill independent obligations under other areas of law, including UNCLOS, including human rights law. And that is something as well that we've been saying for many years, that 1.5 itself is not ambitious enough to protect people's rights. And they acknowledged, in a sense that the harm is here, it's ongoing, and an obligation to cease that harm, an obligation to ensure non-repetition. These are things we've been talking about and addressing, and there are recent reports of the Secretary General on loss and damage, and we'll have another one upcoming on just transition. So I mean, what we heard today, I think, will be a fabulous basis for our ongoing work. I really hope it gives us momentum in the context of the discussions upcoming at COP30. And I also see it building upon, right, all of this other jurisprudence, all of the work that's been done to push for recognition of the right to a healthy environment, to ensure that loss and damage is actually addressed in some way, shape, or form. And they made it very clear that there are obligations in that respect, right? That there are obligations to remedy the harm, to prevent it from continuing. And they're connected with best available science, the highest ambition possible, et cetera. And the other thing I would flag is they didn't restrict their findings to climate. They talked about the environment as a whole, right? And they talked about a duty to protect the environment from irreversible harm. They talked about foreseeability. They talked about the precautionary principle, and measuring the magnitude of risk versus the certainty of science, and all of the things really that those of us working in the human rights and environment space have been pushing for, were touched upon in this decision in a way that I think will be incredibly impactful for how we can engage going forward. And I know we wanted to be quick, but I did want to say, because you asked me earlier if I could flag some of the ways that we might be able to use this going forward. This is like what the IPCC is to the science, the ICJ is to the law. So I think us being able to refer to their advisory opinion in the context of any advocacy and work that we're doing on climate change will be invaluable. And I'm really looking forward to exploring the questions that they didn't quite answer in the context of issues of attribution and causality and compensation. They made it clear that they felt the international legal system could address these issues, but that there should be a context-specific, case-by-case evaluation, right? And so that's one of the next steps, is how do we push for the further evolution of law, drawing upon this decision with respect to responsibility for the impacts of climate change. We have plastics negotiations happening in a week and a half here in Geneva, and I think another thing that they talked about, the role of the private sector, the duty to effectively regulate, et cetera, is quite relevant to that context, and the duty to prevent, again, serious harm. That's part of the effort, and the plastics and climate negotiations are linked, right? And the crises are linked. So that's a very first space where we can, I think, start drawing upon some of the language here of the ICJ and trying to use it to help inform negotiations. But then COP30 upcoming, another huge opportunity. Normally there's a General Assembly resolution which will follow the issuance of the advisory opinion. So thinking about how we can engage with the discussion and negotiation of a General Assembly resolution in the coming months, thinking about how the Human Rights Council can potentially address this and the special procedures mechanisms of the council, et cetera. I will stop. Yeah, but I just say I'm very excited about this, very glad and grateful to Geneva Environment Network and the Center for International Environmental Law for the invitation, and happy to have been here with all of you to experience the reading of the opinion.
Thank you, Ben. We will wrap up now. We will have a very small reception to further discuss and share reactions. Thank you so much once again. I will leave the final words to Claudia, because you mentioned the plastic treaty negotiations and the Geneva Environment Network as a very full program of activities. So over to Claudia, and you can also wrap up yourself, and we can then move to some food and refreshment. Thank you.
Thank you, Francesca. And on behalf of the Geneva Environment Network, warm thanks to everyone for being here today and for your insights. So let me just bring to your attention an upcoming event related to human rights that the Geneva Environment Network and partners will be organizing next week. As Ben just mentioned, the fifth resume session of the INC on plastic pollution will come to Geneva in just a couple of weeks. And this event will stress the urgent need to align existing human rights framework with the upcoming global plastic treaty. So feel free to join us on 29th of July. And also allow me to bring to your attention a page that the Geneva Environment Network has been collecting information about activities that will take place in the margin of the plastic treaty negotiation. You can find it on our website, and if you're organizing an event, a reception, artistic or cultural demonstration, feel free to fill the form that you find on the page. So with this, thank you once again for joining this session, and see you soon. Thank you.